Welcome to this lecture sponsored by the Institute of World Politics. For those of you who are new, IWP is the Independent Graduate School of National Security, Intelligence, and International Affairs. We offer a doctoral program, 7 master's degree programs, including 2 online MAs and 18 certificates of graduate study. If you are interested in learning more about us, please visit us online at iwp.edu. We'd like to thank all of our supporters who make our IWP events program possible. To support the work of IWP, please visit iwp.edu/donate. Today we are here to listen to Dr. Marcin Romanowski. Mr. Romanowski is a Polish politician and a lawyer. His career in public service saw him serve as a Undersecretary of State in 2023, advancing to Secretary of State in the Ministry of Justice later that year. After a shift in the Polish political landscape, Romanowski faced political persecution under the Tusk regime, leading him to become the first political refugee from Poland since 1989. He was granted asylum by Hungary. Dr. Romanowski, the floor is yours.
After a year of escalating lawlessness in Poland, I became the first Polish political refugee since communism, a member of the opposition, a parliamentarian who, due to political persecution and the lack of access to a fair judicial system, was granted political asylum in another EU member state in Hungary. With direct knowledge of the case, I have devoted this lecture to the Justice Fund case, in which the prosecution sought to bring charges against me. This case has been framed by politicians of the ruling liberal camp and pro-government media as the biggest scandal of conservative government in Poland. I will expose the absurdity of this claim and reveal the true nature of the case, a textbook political witch hunt. Its trajectory lays bare the depth of lawlessness under Poland's current liberal government and the extent to which both domestic and international institutions have been weaponized for political persecution. The Justice Fund is a state-designed fund administered by the Minister of Justice. Its resources do not come from taxes, but from financial penalties paid by criminals and are allocated to public tasks, including victim assistance, post-penitentiary support, and since 2017, crime prevention. The implementation of projects can be entrusted to NGOs and since 2017 to public finance entities as well. As the direct supervisor of the fund from 2018 to 2023, I undertook numerous initiatives to build a nationwide network of victim support centers, providing structured assistance, mainly psychological and legal. Within this framework, a Center for Victims of Domestic and Sexual Violence, the archipelago of islands free from violence, was to be established by the Profeito Foundation, whose president was Father Michael Olszewski. The construction of this center was halted by the liberal administration at the final stage in the beginning of 2024, and the main accusations in the case revolve around this project. The entire network of victim support centers was designed to function as a coherent wall with legislative solutions prepared by my team in the Ministry of Justice to combat domestic violence and violence against children. Two laws passed by Parliament introduced measures modeled on Austrian solutions, phased in immediate 14-day police order for a perpetrator of domestic violence threatening life or health to leave the residence, and along with a restraining order. Bans on entering specific locations, for example, schools, and prohibition on contacting the victim. Without any woke ideology, these laws provided the police with an effective tool, while also motivating offenders to undergo, for example, anti-alcohol therapy by abruptly removing them from their comfort zone. Another law prepared by my team in the ministry and passed by the Polish parliament was the so-called Kamil's law, named after an 8-year-old boy who was tortured to death by his stepfather. The boy's death in 2023 served as a catalyst for lawmakers practically across political divisions to adopt legislation laying the foundation for a comprehensive child protection system against violence. It also introduced a national plan for combating sexual crimes against children based on the We Protect Global Alliance model, also prepared by my team in the Ministry of Justice. Another area of action in the framework of Justice Fund involve crime prevention projects. Since the allocation of funds had to align with the Ministry of Justice's policies, I also finance preventing projects that had previously been neglected by the Polish liberal governments for ideological reasons. This included initiatives protecting religious freedom and combating Christianophobia, fighting against Polonophobia, and supporting the family as the best protective environment for children against the dangers of woke ideology. I have no doubt that the furious attack on the Justice Fund stem from the fact that that we supported causes that liberals would most eagerly destroy. One of the first decisions following the unlawful takeover of the National Prosecutor's Office in January 2024 was the creation of prosecutorial team number 2, specifically tasks with investigating the case of the Justice Fund. The establishment of such a team within the National Prosecutor's Office underscores the immense importance attributed to this case. Incidentally, it's worth noting that team number 1 has been handling for several years now the case of the death of the President of Poland and nearly 100 other individuals in Smolensk in 2010. In other words, the Justice Fund case is supposedly the second most important matter for the current Polish prosecution service. Well, absurdity and madness are the mildest way to describe this fact. In March 2024, the prosecution carried out a coordinated operation searching the homes of dozens of people, including former Minister of Justice Zbigniew Ziobro, myself, and two other members of parliament from the opposition's party, of course. 3 individuals were detained and later placed in pre-trial arrest. Father Michael Olszewski from the aforementioned Profeto Foundation and 2 of my former colleagues from the Ministry of Justice, ladies Urszula and Karolina. In this lecture, I will start by describing the nature of the charges against me. In the second part, I will outline the course of the proceedings, during which scarcely a week passed without the authorities violating the law, often through actions that constitute criminal offenses. I think it is worth stating at the outset that contrary to repeated insinuations in the media, even these absurd accusations do not concern corruption or the misappropriation of any property for personal gain. Neither I nor my associates are accused of such things. The first set of charges revolves around the claim that I allegedly unlawfully influence the decisions of competition committees, resulting in funds being allocated to organizations, to NGOs that, according to the prosecution, should not have received them. The absurdity of these charges lies in the fact that the prosecution conveniently ignores one fundamental fact. Under the law, it was not the competition committees that made the final decisions, but rather I, as the fund's administrator, who had brought autonomy in this regard. The entire procedure was not based on a strict public procurement law, and the committees merely issued non-binding recommendations. Interestingly, by some strange coincidence, practically all the questioned projects and organizations have a Christian or conservative profile. Because of this, the prosecutor accuses me of having obtained a personal benefit, which in reality is the only benefit I have gained from this entire case, namely the satisfaction of financing projects that align with my conservative and Christian worldview. This benefit increases the potential penalty to up to 10 years in prison. Let me emphasize that all projects were implemented and realized as proposed. In particular, the Profeto Foundation Center building was constructed, and experts estimate its value to be higher than the funding the foundation received from the Justice Fund. As I mentioned, according to the law, I and not the committees had the right and duty to make decisions, and the projects should align with the ministry's policy direction. One specific charge from this category could, in theory, have some merit. That is, that I allocated funds to an organization that, according to the prosecution, did not meet the formal requirements. If that were true, it would indeed be a violation of the law. However, the prosecution's argument for this alleged non-compliance is that the organization statute, in this case, once again, the Profeto Foundation of Father Michael Olszewski, did not explicitly list objectives that verbatim matched the wording of the competition's call for proposals. Such an accusation is outright absurd. There is no legal requirement for such literal alignment, which has been confirmed by precedent and practice. What is most outrageous, however, is that under the current Minister of Justice, during a similar competition process, an NGO raised the same issue and was told by the ministry that such a requirement does not exist. In other words, on one hand, Adam Bodnar, the prosecutor general, is demanding a 25-year prison sentence for me for something that, according to Adam Bodnar, the Minister of Justice, is perfectly legal. And for the same reason, he kept Father Michael, ladies Ursula and Carolina, in detention for 7 months. The case against me consists of 5 primary already mentioned charges, while the remaining 5 are more procedural, formal in nature. 2 of these claim that I acted without authorization. At the ministry, I initially served as an undersecretary of state, but after 2023 elections, when I became a member of parliament, I held the position of secretary of state for my final months in office. The responsibilities of deputy ministers are determined by a competence ordinance issued by the minister. The investigators argue that since the minister changed my title from undersecretary to secretary by amending the existing ordinance rather than issuing a new one, I was supposedly acting without authorization. Frankly, as a university lecturer, if a first-year law student gave me such an argument during an exam, they would fail. Every lawyer knows that in Polish legislative practice and theory, an amending act has the same legal force as a new act. While reviewing my case files during the pre-trial detention proceedings, I came across a document explaining how such an absurd claim ended up in the prosecution's charges. The circumstances behind it are both unserious and embarrassing for the law enforcement authorities. Unfortunately, I cannot go into detail, as doing so would mean disclosing investigation materials. However, I can say that I have already filled a report on suspected crime in this matter, as I believe that a charge was brought against me due to the manipulation of evidence. The remaining 3 charges concern the fact that I did not recuse myself from overseeing the settlement of research projects that had been carried out at the Institute of Justice, an institution I previously headed before I became Deputy Minister of Justice. The Institute is a public research unit under the Ministry of Justice. It is, in fact, part of the ministry, and these research projects were successfully completed. The prosecution was not satisfied with the fact that I did not interfere in their financial settlements once I took on my new supervisory role over the fund. They charge me for failing to formally recuse myself from oversight, despite the fact that there is no specific legal provision requiring such recusal. Violating legal provision is a necessary condition for filing criminal charges. What's more, Polish administrative law does not even have a concept of recusal from oversight. Meanwhile, in criminal law, in criminal procedure, there is an explicit requirement for prosecutors to recuse themselves if there are doubts about their impartiality. This creates a fascinating paradox. The very prosecutors who committed the criminal offenses of unlawful detention against me, and who had, because of that, a clear legal duty to recuse themselves, did not do so, even after I formally requested it. Yet the same prosecutors are charging me for failing to recuse myself from oversight, a concept that does not exist in law. This is what legal application looks like in militant democracy in Poland nowadays. The most serious charge, supposedly the one that ties everything together, is the accusation that I was part of, or better, I led an organized criminal group. It is also the most absurd, despite the gravity of the situation. First, there was no crime. Every action taken by me and my colleagues, as described in the 10 charges, either never happened or was entirely legal. Second, Polish criminal law does not allow for the combination of participation in an organized criminal group with official misconduct, which is precisely the nature of the accusations against me and my colleagues. According to Polish criminal code, a criminal group is formed to commit crimes, whereas a governmental office is not, although some radical libertarians or anarcho-capitalists might disagree. If we followed the prosecution's reasoning, practically any offense committed by 3 or more people in a school, in an NGO or a business would qualify as participation in an organized criminal group. One legal expert even jokingly remarked that if any of us had been licensed to own a firearm, the prosecution would have labeled us as an armed criminal group. But of course, the real reason for this charge is media optics. It was designed to create the headline: an organized criminal group in the Ministry of Justice led by Zbigniew Ziobro, the very symbol of the conservative fight against crime. It is also served to justify pretrial detention by invoking the threat of a severe sentence. In February 2025, the prosecution decided to present 8 additional charges, de facto duplicating earlier ones. 2 of them concerned the previously mentioned area, namely the alleged influence on the decisions of competition committees, despite the fact that these committees did not make any decisions. The remaining 6, like the previous 2, were of a formal nature and concern the alleged lack of authorization. Unfortunately, at this stage of proceedings, I cannot discuss the details of the prosecution's evidence, as doing so would expose me to charges of obstructing the proceedings. At this point, it can be stated that the prosecution's so-called evidence in no way confirms that I issued any unlawful orders during the preparation of competition recommendations or at any prior stage. The primary source is the statements and secret recordings made by a former official in the Ministry of Justice, Tomasz M., who is represented by one of the leading politicians of the ruling liberal coalition, Roman Giertych. Tomasz M. is seeking the status of so-called small crown witness, a legal status that allows for leniency in sentencing in exchange for testifying against others. The fundamental problem is that this type of witness is already a suspect in the case and has every incentive to fabricate allegations against as many people as possible. Polish court rulings make it clear that testimony from such a witness must be treated with extreme caution, and they have a vested interest in accusing others to secure the best possible deal for themselves. Both the current Prosecutor General Adam Bodnar and MP Roman Giertych, the lawyer representing Tomasz M., are not just active, but highly active politicians within the ruling liberal coalition. Roman Giertych is one of the most aggressive politicians in the liberal civic platform party, demanding political settlements against representatives of the previous conservative government. The important reason for this is that until recently he himself was suspect in a serious criminal case, which I discuss in another lecture. For many months, he remained abroad, evading prosecution. He returned only after the liberal majority took power. Following the illegal takeover of the prosecution service, the proceedings against him were dropped in January 2025. In this very case, he remains politically aligned with the prosecutor general and openly pressures the prosecution to act more forcefully. He has admitted that he prepared the testimony of Tomasz M. and that he has spent hundreds of hours working on this case. The circumstances of the case make it also clear that the prosecution's actions regarding the justice fund are politically driven and amount to an act of personal revenge against the largest opposition parliamentary group, with a particular focus on the circle surrounding former Minister of Justice Zbigniew Ziobro. The prosecutorial team leading the case consists of the current minister's most trusted operatives, many of whom are closely linked to the politicized Lex Super Omnia Association of prosecutors and were sidelined during Ziobro's tenure. Under standard criminal procedure, they should have been excluded from the case due to their clear personal motives for retribution. Beyond personal vendettas, liberals are also using this case as a tool against an ideological opponent, a conservative political environment that has consistently resisted radical climate policies and the programs built upon them, rejected gender ideology, and opposed the EU centralization agenda, which seeks to curtail or even dismantle the sovereignty of member states of the European Union. I also have no doubt that the motive of revenge is connected to my personal involvement. Previously, as deputy minister, I was responsible, among other things, for protecting the Polish legal order from woke-driven initiatives, including those from the EU, which we blocked, often in cooperation with Hungary for years. Later, as a member of parliament from December 2023, I repeatedly intervened and filed legal motions regarding suspected crimes committed by Donald Tusk or his ministers, Bartłomiej Sienkiewicz, Adam Bodnar, and others, concerning numerous illegal actions by high-ranking government officials, such as the unlawful takeover of public media and the prosecution service, or the illegal detention of opposition MPs. The unlawfulness of the actions taken against me begins with the illegitimacy of the entities involved in the case. Prosecutorial team number 2, which is leading the charges against me and my colleagues, was created at the request of Jacek Bilewicz, who was unlawfully appointed to a non-existent position as acting national prosecutor. The investigation was then extended by Dariusz Korneluk, who was also illegally appointed as a national prosecutor. It was Korneluk who submitted the request to the Polish Sejm in June 2024 for permission to prosecute and arrest me. These circumstances render the decisions and actions taken in the case either null and void or fundamentally flawed. But the most spectacular violation of the law was my arrest on July 15, 2024, in a clear violation of international law, as I not only had domestic immunity, but also immunity as a member of the Parliamentary Assembly of the Council of Europe. On the day my Polish parliamentary immunity was lifted, Friday, July 12, I voluntarily presented myself at the prosecutor's office, but none of the prosecutors wanted to question me. Has anyone ever heard of the leader of a dangerous organized criminal group voluntarily walking into the prosecutor's office only to be told to leave because no one had time for him? Well, that's exactly what happened, and this so-called boss is speaking to you now. Additionally, on Monday, July 15, my attorney, Bartosz Lewandowski, called the prosecutor's office in the morning to inquire about my voluntary appearance. He had previously, on Friday, submitted a letter stating my readiness to appear whenever summoned, and had provided all necessary contact details. But he was told to wait. A few hours later, in the early afternoon, dozens of armed and masked officers stormed my parliamentary apartment in central Warsaw. I was ordered to strip naked and was handcuffed. Handcuffs were then used on me throughout the entire transportation process in the following days. They followed procedures reserved for dangerous criminals. I was taken out of the apartment in handcuffs under the glare of cameras from every television station. There is no doubt that the entire operation was staged as a media spectacle. Well, this visit was in some way surprising to me, because it was obvious that my detention was illegal without the lifting of my international European immunity. And there is no basis to claim that the prosecution was unaware of this fact. The case was public, and well-known liberal lawyer specializing in human rights had even commented on X about the legal issues surrounding my immunity of Parliamentary Assembly of the Council of Europe members. It later emerged that seeing what was happening, Polish authorities had been warned by Strasbourg regarding my case. Meanwhile, to justify the unlawful actions, the Minister of Justice, an expert in the human rights protection system of the Council of Europe, commissioned two legal opinions written not by specialists in the field, but by friendly constitutional law experts. One had no date and other had no signature. I do not want to bore you with an analysis of these so-called legal opinions, but it is hard to avoid the impression that they were clumsily drafted to fit a predetermined narrative, one that, of course, directly contradicts the legal framework of the Council of Europe. One might wonder why they decided to arrest me. Most likely, they did not expect the chairman of the Parliamentary Assembly of the Council of Europe to intervene so quickly. Yet he did so the very next day. In similar cases, such interventions usually took weeks. They probably hoped that in the meantime I would become intimidated and that they could coerce me into providing false statements incriminating Minister Ziobro or other opposition politicians. They had already demonstrated what they were capable of by persecuting others who had been placed in pretrial detention in connection with this case. Perhaps they also believed that they could use their influence within the Council of Europe to defuse the situation, which in the end they managed to do. They undoubtedly felt emboldened, convinced that they could disregard even international law. After all, they had been doing the same domestically without consequence. Acting based on private legal opinions was the very method they used to seize control of the National Prosecutor's Office, as discussed in another lecture. It was enough to find 2 or 3 lawyers willing to write whatever was needed for a fee of $2,000 or $5,000, even if their opinion blatantly contradicted to the wording of national or international regulations. Later, we would learn that such an author of one of the so-called legal opinions, and quotation marks are necessary here, had been rewarded with a lucrative position on the supervisory board of a state-owned company. That is why when I filed a criminal complaint over my unlawful detention, it also included the authors of these 2 opinions, categorizing their actions as aiding and abetting. After some time, I experienced a small sense of satisfaction upon hearing that the government was searching for experts to justify the blatantly illegal blocking of public subsidies for Law and Justice, the largest opposition party, and yet no one was willing to take on the job. The chilling effect worked. Unfortunately, this did not stop the government from continuing to withhold these funds, but it certainly made things more difficult for them. However, that will be a topic for another lecture. Returning to the subject of this one. After my detention, the prosecutor formally presented the charges against me, which I have already described, the 11 ones, emphasizing the illegal nature of the prosecution's actions on multiple levels. I submitted an extensive statement addressing this absurd accusations. I say statement because it was not a suspect's explanation as defined in the Polish Code of Criminal Procedure, since I declared that, in my view, I did not hold such a status, given that the charges against me were legally ineffective, and the entire procedure did not constitute a legitimate interrogation of a suspect. Later, in the following months, this was confirmed by courts in 3 rulings. This peculiar social gathering ended after midnight. Since it was not a legal interrogation, the term social gathering seems to be the most accurate description of the event, although it was certainly not my company, and the manner of the invitation was, to say the least, highly unconventional. Well, the next day I was given mere 3 hours to review the accessible portion of the case files, which comprised over 100 volumes. The review was interrupted, so I could be transported to the Warsaw Mokotów District Court for a hearing on my pre-trial detention. It is worth noting that this court has jurisdiction over detention requests in cases handled by the National Prosecutor's Office, meaning the most serious cases. Furthermore, on July 12th, so 4 days before, the vice president of this court, responsible for criminal cases, announced his resignation, citing political pressure from the Minister of Justice. At the hearing, my defense attorney once again presented arguments demonstrating the prosecution's illegal and baseless actions. The court postponed its ruling until the following day, but events unfolded more rapidly. The judge, alerted by my lawyer about the official protest from the chairman of the Parliamentary Assembly of the Council of Europe, addressed to Speaker of the Polish Sejm, accelerated the hearing and scheduled it for 11:30 p.m. that same night. Well, I must admit that at first I had mixed feelings when a guard entered my cell while I was already asleep, woke me up and told me he had both good and bad news. One was that it was 11 p.m. The other was that they were coming for me. The hearing lasted 29 minutes and ended just before midnight. the court had no choice but to order my release. Everything unfolded in rather dramatic and at the same time striking circumstances during a nighttime hearing accompanied by crowds of journalists broadcasting live from outside the court house. The day after my failed arrest, the Minister of Justice publicly threatened my defense attorney, stating that he would launch an inspection against the private university where he had once served as rector. Such was his fury at the effectiveness of my lawyer's actions. Already in December 2024, while I was being sought by Polish authorities, one member of European Parliament publicly threatened my attorney with prison time if he did not disclose my whereabouts, something that would have constituted a clear violation of attorney-client privilege. At the same time, after the day after my release, all pro-government media outlets, as well as ruling liberal politicians, pro-government experts, launched a coordinated smear campaign. They accused both me and my lawyer of abusing the law, hiding behind immunity, and preemptively declared my guilt, not only for the charges the prosecution intended to bring against me, but also for crimes I was never even accused of, such as embezzlement. The Prime Minister himself went so far as to question the validity of my Council of Europe immunity. This media witch hunt, orchestrated by the ruling coalition's politicians, government-aligned journalists, and their hand-picked experts, had been a constant element of this case. It was included the selective leaking of evidence to the media during the European Parliament election campaign in April and May 2024, as well as defamatory attacks. The campaign has been accompanied with numerous threats. Calls for my death, physical assault, crimes of sexual nature, along with insults and slander spread via social media and online comments. Interestingly, in July 2024, the most prominent legal authorities of the liberal establishment were deployed for the cause. Figures such as Professor Marek Safian, former president of Poland's Constitutional Court and former judge of the EU Court of Justice, and Professor Andrzej Zoll, former ombudsman and former president of the Constitutional Court, appeared in the media voicing opinions that conveniently aligned with the prosecution's arguments. However, the positions were in clear contradiction with the unequivocal wording of the Council of Europe's resolutions, the stance of the chairman of the Parliamentary Assembly of the Council of Europe, and the opinions of real specialists who have studied this issue for years and have published extensively on it in academic literature. In this context, it is worth recalling the inscription of the tombstone of Saint-Yves Ellery de Camertown, the patron saint of lawyers who lived in 13th century in France. Advocatus et non latro res miranda populo. This translates to a lawyer and not a swindler, an astonishing thing for the people. Well, this praise implicitly reflects a historically negative assessment of the professional integrity of lawyers, an assessment that unfortunately remains just as relevant today. And the entire cast of so-called legal experts involved in this case would very well be considered the rightful heirs of that critique. It also seems to me that the explanation for their actions lies in the deep internalization among the legal authorities of the current Polish Third Republic of a belief similar to that of Louis XIV of Bourbon, la loi c'est moi, I am the law. They believe that their opinion carries legislative power, that it has a performative quality, altering the legal reality by their mere declaration. Even if it were contrary to the clear and plain wording of the law. The liberal establishment simply cannot fathom the idea that they might no longer be owners of the state. But in this case, the truth has been exposed and the king was necked. Well, unlawful deprivation of liberty is a crime that should be prosecuted ex officio. True, it was only 2 days I was still deprived of my freedom. Needless to say, no proceedings have been initiated in this matter. A few days after this event, I filed a criminal complaint regarding the suspected offenses of unlawful deprivation of liberty and abuse of power, as did the Law and Justice Parliamentary Club. For many months, nothing happened. In a rule of law state, high-ranking government officials responsible for the illegal detention of an opposition MP would be immediately dismissed. However, in my case, it is the Minister of Justice and even the Prime Minister, along, of course, with the prosecutors involved, who bear responsibility, not only political, but in my opinion, also legally. Moreover, in a rule of law state, prosecutors suspected of such misconduct would be removed from the case. Yet in my case, they continue to handle the proceedings in blatant violation of criminal procedure. And who decided on my motion to exclude them? None other than the Minister of Justice, Adam Bodnar, potentially the main suspect in this case. He did so in a direct violation of criminal procedure, as he's not a career prosecutor and thus has no legal authority to make such a decision. Additionally, he violated the Constitution since, as a senator, he cannot perform the duties of an active, regular prosecutor. According to the Polish Constitution, holding both a senatorial mandate and the prosecutorial position simultaneously results in the automatic expiration of the senatorial position. Naturally, I submitted an official request to the Marshal of Senate regarding this matter. In fact, this was my second such request. The first concerned Bodnar's personal takeover of the case regarding the unlawful changes in public media, which I have discussed separately. Both requests were ignored. Adam Bodnar made this decision personally because otherwise the case would have been handled by one of his deputies appointed during the tenure of the previous Minister of Justice, officials who would certainly not have allowed such violations of the law and who would have granted my motion. It should also be noted that I submitted a request for disciplinary proceedings against the prosecutors responsible for these violations. To my knowledge, no such proceedings have been initiated. Instead, Adam Bodnar publicly praises these prosecutors for their work. And if there is any criticism of them from within government circles, it concerns only the fact that their actions have not been fast or aggressive enough. It is also highly important mentioning that in addition to the Warsaw-Mokotów District Court's ruling on July 16, 2024, rejecting the prosecution's request for my pretrial detention, two further court decisions have confirmed the illegality of my deprivation of liberty. First, on September 27, 2024, the Warsaw Regional Court upheld the District Court's ruling rejecting the prosecution's appeal. Then on November 21st, 2024, the Warsaw-Mokotów District Court ruled in a complaint proceeding at my request that my arrest had been unlawful. The prosecution filed an appeal against the district court's decision to release me and dismiss the request for my pretrial detention. Interestingly, they used similar arguments to those presented by the Russian Federation in 2014 in Savchenko case, disputing the nature and scope of the Council of Europe's immunity. The prosecution also attempted to exclude the judge who had been randomly assigned to hear the appeal, basing the request on the fact that he had been promoted after 2018, and therefore, according to liberal politicians and liberal judges, was considered as neo-judge. The request was rejected, ironically, by a judge who was not part of that so-called neo-judge group. Nevertheless, politically engaged judges attempt to manipulate the composition of the adjudicating panel. Specifically, one such judge, Krzysztof Chmielewski, who was handling a collateral case related to the panel in my case, took it upon himself accidentally and without any legal basis to revisit an already settled matter. Having access to my case files, he decided to override the previous legally binding ruling and exclude the judge in question, despite an earlier decision denying such an exclusion. This was a blatant violation of the due process of law principle stated in Article 6 of the European Convention on Human Rights and in Article 45 of the Polish Constitution. Notably, Judge Chmielewski is a political agitator who has consistently demonstrated his bias in favor of the ruling liberal coalition on the platform X. He has regularly posted comments sharply attacking conservative opposition politicians and state officials, crossing the boundaries of judicial impartiality. In response, for example, to my post about a court ruling dismissing proceedings based on my complaint against the celebrity Barbara Kurdej-Szatan for her defamatory remarks about Polish border guard officers, Judge Chmielewski publicly accused those officers of inhuman lawlessness and called them bandits acting on behalf of bandits. This case involved outrageous statements by a celebrity who falsely and absently accused Polish officers of murder, even though they were in reality defending Poland's borders against a coordinated destabilization campaign orchestrated by Lukashenko and Putin regimes. These attacks from abroad relied on the mass exploitation of so-called refugees who were in fact illegal immigrants deliberately organized by Moscow and Minsk. These actions began several months before Russia's invasion of Ukraine and were clearly aimed at destabilizing Poland in advance. However, this attempt failed as Poland resisted not only the hybrid attack on its borders, but also the Soros-funded campaign led by liberal organizations and celebrities with the involvement of the institutions of Council of Europe. Yet, despite these facts, Judge Chmielewski directly accused the border guard of criminal activity. Another example of his bias, after I posted a critical comment about the EU's climate policy and the centralization of power within the European Union, he responded in a crude manner writing, you should change your medication or your doctor. And yet, this is the same judge who was making rulings on the alleged lack of impartiality of other judges in my case, while himself violating legal provisions in at least one instance. Judge Chmielewski's attempt at judicial manipulation ultimately failed because at the time the court administration had not yet been fully taken over by the Minister of Justice. The situation in Warsaw's courts, however, has since changed dramatically. The Minister of Justice has unlawfully purged all independent court presidents, effectively pacifying the judiciary. Well, as a result, in another case in January 2025 regarding the detention and forced escort of former Minister of Justice Zbigniew Ziobro to a hearing before an illegal parliamentary investigative commission, the court authorities engaged in overt manipulation. Randomly selected a judge twice to ensure they got the right one. It is also worth noting that throughout this case, the case of Justice Fund, judges with overt political affiliations have frequently presided over key rulings, despite the fact that they should have been disqualified. For example, in one of the detention hearings for Father Michael Olszewski, the judge assigned to the case was a former Deputy Minister of Justice before 2015, a close associate of Donald Tusk. In my own pretrial detention hearing in December 2024, the judge presiding over the case had previously ruled in a high-profile case involving the pro-life van driver. This van had been driving around Warsaw, displaying messages about protecting children from LGBT ideology. In 2023, the judge ruled that an individual who had physically assaulted the driver had not committed a crime because he acted out of civic motives and that the attack was not socially harmful. Long before this ruling, as Deputy Minister of Justice, I had successfully intervened with the Mazovian voivode to annul a ban imposed by Warsaw Liberal Major on the van's movement on the city, on this van movement. I also awarded a medal for meritorious service to the justice system to an activist from this foundation, which triggered absolute outrage in the liberal media. And in 2023, I had publicly and harshly criticized this judge on X for her disgraceful ruling mentioned above. These are the kinds of people, of judges ruling on cases involving me and others in the case, including opposition politicians. According to defense attorneys, the treatment of three individuals who had their pretrial detention repeatedly extended met the modern definition of torture. In December 2024, the Polish ombudsman, who had been appointed during the previous parliamentary term, but recommended by a party now in ruling Liberal coalition, published the findings of a report concluding that these individuals had been subjected to inhuman treatment and violations of their rights and freedoms. For example, they were subjected to prolonged procedures lasting several hours without breaks while being kept in handcuffs. High security handcuffs were used without any necessity. Loud music was played in the cells. Access to legal counsel and spiritual care was restricted. They were deprived of food. And male officers conducted strip searches on female detainees. These are just a few of the documented abuses. However, beyond confirming the use of such practices against political prisoners, the report reveals something even more significant, namely the extent to which the judiciary is now subjugated to the ruling authorities. Such a thesis is entirely justified because allegations of torture in this case had already been reviewed by a Polish court, which found no violation. Null. This outcome was hardly surprising, given that the presiding judge, Joanna Włoch, failed to examine nearly any of evidence requested by the defense and instead relied solely on statements from the various state institutions accused of perpetrating the torture. Had it not been for the Ombudsman's report, the entire affair would have been quietly buried. However, so far, no one has been held accountable, and there is little reason to expect that will change. After all, many of these actions could not have occurred without the knowledge or even approval of Prime Minister Donald Tusk and Minister of Internal Affairs Tomasz Siemoniak, who oversees the Internal Security Agency, the institution directly responsible for the detentions. Likewise, the Minister of Justice, who controls the prosecution service that determined the treatment of detainees as well as the prison service, would have been fully aware of these practices. It is also known that officers received explicit orders during a briefing session before the detentions, instructing them to act brutally. Given that the case was officially classified as the second most important case in the country, there is no doubt that these decisions were made at the highest levels of government. A violation of the law also occurred during the revocation of my European immunity. It is worth emphasizing that I never intended to hide behind immunity, something I have repeatedly stated openly. In the case of my Polish parliamentary immunity, such a strategy would have been absurd anyway, as the ruling coalition already had the majority needed to revoke it. However, I pointed out the illegal nature of the process. The request came from fraudulent national prosecutor. I explicitly communicated Liberal MPs that I would not resign my mandate so that in the future they could be held accountable for the lawlessness they were actively enabling. Regarding my Council of Europe immunity, my goal was to use the debate as an opportunity to expose the rampant lawlessness unfolding in Poland. However, this never materialized as the left liberal majority in the Parliamentary Assembly, bolstered by Tusk's political connections, rushed the matter through with astonishing speed. The request was submitted on Sunday, placed on the agenda on Monday, and the same day, just half an hour before midnight, an email was sent to me informing that the Rules Committee responsible for reviewing the request would meet the following morning on Tuesday to discuss it. According to Parliamentary Assembly regulations, I had the right to respond to the charges and present relevant documents. In reality, I was given just one night, or more precisely, barely 1 hour. I only learned about the hearing schedule from my colleagues, as I hadn't seen the email overnight. Properly preparing and translating the necessary materials with a sworn translator is a process that requires far more time. The chair of the Rules Committee, Heike Engelhardt, a German socialist, volunteered to be the rapporteur of my case, ensuring that nothing would disturb the process of forcing it through. I won't even dwell on the small procedural oversight that I was not even provided with the content of the charges against me. I officially learned the details, the whole document post factum from an email sent by Theodoros Rossopoulos, the president of Parliamentary Assembly, informing me that my immunity had been revoked. Rosopoulos and Engelhardt, the key decision makers in the case, knew perfectly well, because my lawyer had been keeping them updated since July they knew about all the illegal actions surrounding my case, which clearly demonstrated political persecution rather than genuine pursuit of justice. My unlawful detention, the lack of legal authority of the so-called national prosecutor, threats against my defense attorney, the torture of other detained individuals in the case, and the fact that the case should have been dismissed due to the ineffective filing the charges in July, making the request to the Assembly entirely baseless. These were all factors that the Rules Committee and Parliamentary Assembly was obliged to consider, since it has a duty to determine whether a request is aimed at justice or political persecution. Additionally, 3 days before the Assembly session, 2 pivotal court rulings were issued. First, regional court upheld the rejection of my arrest. Second, the Polish Supreme Court confirmed that Dariusz Korneluk is not the national prosecutor, and Dariusz Barski, who was unlawfully removed from office, remains the legitimate holder of that position. One of the core duties of the Rules Committee of the Council of Europe Assembly is to ensure that request originates from the appropriate authority. On that basis alone, it would have been entirely reasonable and necessary to at least await the written justifications for this ruling, or just both rulings. Yet political expediency prevailed. At the very last, I had the opportunity to see firsthand how realpolitik operates in an organization that was supposed to stand as a guardian of human rights and democratic standards, yet flagrantly violated them in this case. The ultimate insult and height of hypocrisy was the Parliamentary Assembly resolution expressing regret that I had not taken the opportunity to respond to the charges. Well, following the unsuccessful attempt to present charges against me, as was already said, a Polish criminal procedure required that the case be dismissed. Any potential reopening of the proceedings based on new circumstances and evidence would have required the approval of a superior prosecutor. This never happened despite my formal request to the prosecution. Most likely, this was because the overseeing prosecutor was the illegally appointed national prosecutor. As a result, all subsequent proceedings, including the representation of charges in October 2024 and the pre-trial detention request reviewed in December 2024, were fundamentally flawed. Nevertheless, on October 15, 2024, on the request of the prosecutor, I voluntarily appeared at the National Prosecutor's Office, explicitly highlighting all the illegal actions surrounding surrounding my case. During the meeting, I was informed that there had been discrepancies in the interpretation of regulations regarding my previous detention, euphemism for what was in reality a criminal act of illegally depriving an opposition MP of liberty. The prosecution decided to represent the charges against me despite being legally obliged to dismiss the case. They also introduced a new legal qualification, namely misappropriation of property of significant value, despite the fact that all funds that had been allocated, they were allocated in accordance with the designated purpose, and I had never been accused of taking a single zloty for myself. The rationale behind this charge was that, according to the prosecution, by making decisions on the allocation of funds to various entities, I had exercised discretionary control over them. A minor detail worth noting, not only did the law allow me to do this, but it required me to do so. And this legal framework had remained unchanged for many years. This classification, which had no chance of holding up in an independent court, was introduced solely because of the severe penalty associated with it, up to 25 years in prison. It was needed to justify a renewed pre-trial detention request. After some time, I also realized that it served a convenient media purpose for the government supporters, allowing them to falsely claim that I was accused of misappropriation of property. The crucial detail that this so-called misappropriation consisted of allocating funds for public tasks that were actually carried out was conveniently omitted. The shift in legal classification was directly linked to the fact that in an earlier case, the court reviewing the pre-trial detention of Father Michael Olszewski had rejected the original charge under Article 298 of Polish Penal Code so causing damage of significant value through abuse of trust in economic turnover. The court ruled that the activities of the Justice Fund had nothing to do with economic turnover, but were instead exercises of governmental authority. This absurd reclassification culminated in yet another pre-trial detention request filled by the same people who had already committed a criminal offense against me, the illegal deprivation of my liberty in July 2024. Another attempt to deprive me of my liberty, of my freedom, something that ruling coalition politicians and pro-government commentators openly admitted, was motivated by the desire to extract false evidence against the former Minister of Justice and other politicians. The justification for the pre-trial detention request relied on two main arguments: the severity of the potential sentence and the risk of obstruction of justice. Even lawyers sympathetic to the government noted that nearly a year after the investigation began, a claim of risk of obstruction was clearly baseless, especially given that I had fully cooperated with the prosecution, while of course emphasizing the illegality of its actions. Meanwhile, the severity of the potential sentence was purely a result of the absurd legal classification of the charges, such as participation in an organized criminal group or misappropriation of property. Not only just due to the lack of evidence, but also because these legal constructs themselves made no sense in relation to the potential facts of the case. These classifications were designed solely for intimidation, media impact, and justifying pre-trial detention request. The lack of substantive justification made it clear that detention was purely an act of political repression. Numerous aspects of the proceedings indicated violation of Article 6 of the European Convention on Human Rights, so the right to a fair trial, and a real risk of further violations. Nevertheless, on December 9th, 2024, the court decided to impose 3 months of pre-trial detention after rejecting my motion to exclude the judge and even reserving a police transport convoy several days in advance to transfer me to the custody. I was not present at this hearing. A few days earlier, I had undergone a routine medical procedure that had been planned since July. In a completely unexpected turn, it resulted in serious complications. But at that time, however, I was already following events from Budapest, where I had been granted political asylum by the Hungarian state. Thus, at once the planned media spectacle parading an opposition MP in handcuffs failed. Well, for obvious reasons, I will not disclose details regarding the implementation of the asylum decision. However, I believe the reasons for it are clear. Political persecution and the lack of access to a fair judicial process. Unfounded and legally flawed charges, some of which were fabricated through criminal misconduct, wrongfully appointed prosecutorial team, an unlawfully extended investigation, an invalid request to lift my Polish immunity, illegal deprivation of liberty. Proceedings conducted in violation of res judicata principle, the refusal to exclude biased prosecutors, and in effect, a baseless request to lift my European immunity. Manipulations in judicial panel assignments as the Minister of Justice unlawfully installed loyal court presidents. The refusal to exclude judges whose impartiality was in question. The weaponization of evidence leaks in the media for election campaign purposes. Threats from the Minister of Justice against my defense attorney. Media attacks preemptively declaring my guilt. Inhuman treatment, violations of rights and freedoms, and even torture against three detained individuals in the case. These are the key factors. In an open letter to the Minister of Justice published shortly after my asylum decision became public, I made it clear that I have never sought and do not seek any special treatment. Nor do I intend to evade addressing the absurd charges against me. However, this must be done before independent, apolitical, and impartial judicial bodies. The restoration of the legitimate authorities of the prosecution and the courts, the publication of constitutional court rulings and compliance with Supreme Court judgments. The end of judicial panel manipulations in criminal cases regarding politicians. Restoring these conditions of the rule of law and a fair trial is an absolute necessity, not only for the consideration of my case, but for all Polish citizens. Instead, we are dealing in Poland with criminals who have seized control of the prosecution service and are using it as an instrument of political revenge. We are dealing with criminals in white bureaucratic collars, in uniforms, and in prosecutorial and judicial robes. The decision to go into exile was not an easy one. From both a personal and professional standpoint, it would have been simpler and safer to submit to these unlawful actions, endure a year or more of detention, and avoid this uncertainty of exile. However, I concluded that it was necessary to take a more proactive stance, to choose more demanding form of resistance in the face of outright lawlessness in current Poland. I had previously complied with all summonses from the prosecution, despite the illegality of its leadership, an issue confirmed by both the Supreme Court and the Constitutional Court. However, I could no longer tolerate the flagrant lawlessness and outright criminal acts unfolding in my case. I believe the situation is best captured by the words of US Supreme Court Justice Oliver Wendell Holmes, who stated that even a dog knows the difference between being kicked and being stumbled over. Allowing oneself to be imprisoned means condemning oneself to silence. Remaining free not only provides the opportunity to respond to the charges and communicate, but also to draft legislative proposals and undertake other actions aimed at overthrowing the unlawful, ineffective and harmful Tusk's liberal regime that is detrimental to Poland. Yet now political asylum for an opposition politician serves as a clear signal to the international community. Additionally, I never imagined that I would one day practically apply my expertise in transitional justice, the very subject of my doctoral dissertation. The exile stage of political and civic activism is, after all, unfamiliar to Polish history. The tradition of Polish emigration and of Polish-Hungarian solidarity for our freedom and yours has long been a part of Central European political reality. For years, we may have naively believed that history had ended. But it has not, because we make history, and it is our choice whether we will submit to injustice and lawlessness or whether we will fight back.